My name is Dory Nambairi, and welcome to my channel. We are going to discuss the various decrees a court can give during a matrimonial crisis. We have nullity of marriage, we have judicial separation, we have restitution of conjugal rights, and we have attestation of marriage. So the first we're going to talk about today is solution of marriage, which we refer to as divorce. Solution of marriage occurs when the marriage breaks down irretrievably. Now the Matrimonial Causes Act, we have grounds for dissolution of marriage. Imports divorce. Most persons just wake up one thing or the other, they are not really comfortable with their partner. The next thing they are vying for is now to go for divorce. But they don't understand that there are grounds for dissolution of marriage. These grounds are stipulated under the Matrimonial Causes Act include separation, intolerable attitude, when one of the parties has refused to consummate the marriage on the grounds of adultery, when one of the parties is absent for like 7 years in marriage. Then for the part of separation, where I mentioned separation, when one of the parties or where the parties are separated for at least 2 years or 3 years is a ground for separation of marriage. Then desertion too. These are the grounds for dissolution of marriage. So when a marriage has broken down irretrievably, it means that the marriage can no longer hold, like the parties can no longer sustain the marriage. The decree of nullity of marriage declares the marriage void or voidable as the marriage has defects from the beginning. If a marriage is said to be void, it means that from the onset there was no marriage. For instance, a situation where party A, as a man, tries to settle down with party B and disguises to be party C and ends up marrying party B. If such comes to play and the person or the individual in question is exposed, the law sees it as from ab initio that there was no marriage, as the other party was deceived into the union. Then for the issue of being voidable, when a marriage is declared voidable, it means that there are defects in the marriage, but the marriage still succeeds until the court issues an order nullifying such marriage. So these are the grounds where the court can declare nullity of marriage. We're going to look at the next one, which is judicial separation. When such decree is made, parties can live apart or stay apart. The fact that the parties are not cohabiting together does not dissolve the marriage. The parties are still legally married to each other, but they cannot cohabit under the same roof anymore, or they still remain husband and wife. Restitution of conjugal rights. So many persons are going through this at the moment, where one of the parties to a marriage has refused to consummate the marriage and the other party is left in denial, suffering. In this situation, any of the parties can, or the party being denied of the conjugal rights, can approach the courts, and the courts can give this decree reversing the situation, or giving a decree to issue, or instructing the other party to have performing its right. These are basically the decrees that a court can give depending on the situation of the marital crisis. Have a blessed day and continue staying tuned on the page. Thank you. Like and subscribe.